Hello, everyone. I'd like to welcome you to this bonus session of the 2021 North Carolina Airports Association Conference, The Business of Aviation. Thank you for being a part of the conference, and thanks for joining us for this bonus session. Now I'd like to take a minute to introduce our panelists. It really and truly is an embarrassment of riches. I could brag on each of these folks forever, but I am keeping it brief in the interest of time. First, I'll introduce Leila Lahbabi, she is lead counsel for Charlotte Douglas International Airport, where she has worked since 2004. And I will tell you, I know that she was a prosecutor before that. So word to the wise, don't mess with Leila. Then we have Steve Osit, who is a partner in the Denver office of Kaplan, Kirsch, and Rockwell, where his area of practice focuses on many aspects of representing an airport, particularly including issues surrounding the grant assurances we will discuss today. Steve is also a certified pilot. And then we have Pablo Nüesch, who is the Deputy General Counsel of Airports Council International, NA. Before joining ACI, Pablo worked in private practice, representing airports in numerous legal matters, including, again, many of the issues related to the grant assurances we will discuss today. And bringing up the rear, I'm Erin Locklear, and I'm General Counsel for the Raleigh-Durham International Airport. During this discussion, we'll be bringing out some of the most prominent grant assurances that we will focus on, and we'll give you some real-world examples. When analyzing the application of grant assurances, the devil is always in the details, and I think you probably will hear us say that several times during this panel. And in the interest of time, we won't be able to get into all of those details of how grant assurances apply in all situations. So please just be aware that we will be talking at a very high level, but each situation has a lot of important nuance and detail that we just aren't able to discuss in the time constraints that we have. So we're going to go to the next slide, and as you all know, we are going to discuss grant assurances in our panel today. And while you may think of grant assurances as just some legal mumbo jumbo, they are one of the few topics I can think of that impact every aspect of an airport, including every piece of airport property. And here's why I say that. Grant assurances are at their essence promises that the federal government imposes on airport sponsors when it gives grants. In other words, the way I usually describe it is Uncle Sam gives with one hand and he takes with the other. Grant assurances are also, they have their roots in federal law. So the wording of some grant assurances is even taken directly from federal law. And though I won't dig into it here, I have listed a few of the applicable laws in this slide in case you are curious and want to go look those up or learn more. And the title of this panel session is, What Did I Sign? And the reason it's titled that way is because grant assurances are contained in grant agreements that airport sponsors sign in order to receive those grants. And just FYI, there are some other promises that are made in individual grant agreements, so I encourage you to be familiar with the details of those assurances or those agreements. But today we will be focusing on the grant assurances themselves. So this is just a snapshot of a grant agreement that the Raleigh-Durham Airport Authority recently signed, and I've circled just two areas here that I think it's good to note. The first is, I think it's interesting that Raleigh-Durham RDU has 5 sponsors, and each of those sponsors is required to sign all of our grant agreements. So what that means is that each of those 5 sponsors is promising to abide by the grant assurances and the other conditions in these grant agreements. Another thing to note in the second circle is that the grant agreement here references the airport sponsors' adoption of the latest version of the grant assurance. This agreement in particular references the 2014 version. And I point this language out because it shows you a couple of things. First, it shows that the grant is given in exchange for grant assurances. So the grant money is in exchange for grant assurances. And it also shows that grant assurances may change over time. For instance, this language references the 2014 version, and I think it's telegraphing that a change will be coming to incorporate the FAA Reauthorization Act of 2018, which we'll discuss later in this panel. So I mentioned that to say it's important to sort of make sure and check that you are referencing the most recent version of the grant assurances, because they can change over time. So currently, there are 39 grant agreements, and the most updated version can be found on the FAA's website, which is linked here. So speaking of those assurances, this is the beginning of the attachment that incorporates the grant assurances into a grant agreement. As you can see by the circled item, I think that's number 3, the FAA is again hammering home that the acceptance of a grant triggers the imposition of grant assurances. Now, one thing that I haven't mentioned but is important is that each grant agreement also includes an Exhibit A, which is a map that shows all airport property. And this is such a common map that some folks just call it Exhibit A, and airport folks will say, hey, where's your Exhibit A? What's your Exhibit A? It's called Exhibit A because it's the Exhibit A to the grant agreement. So the effect of an Exhibit A is it attaches to the grant agreement, and it means that the conditions of that grant agreement apply to all airport land. And this essentially makes the entire airport a grant-obligated airport. And you may have heard that term before, and it essentially means that the airport has accepted grants and therefore has also accepted the obligations that come with those grants. And as we now all know, those obligations include grant assurances. So to give more detail about how these grant assurances apply to airports, Pablo will kick off a discussion about how they apply to airport property, airport projects, and more. So Pablo.
Thank you, Erin, and thank you for having me in this panel. The common question that is often asked about grant assurances and the applicability of grant assurances is whether the obligations are applicable to the project for which federal funds were received, or to the facilities and the land that was acquired as a result of the project, or to the entire airport. So the lawyerly answer to that question is it depends, right? And there are grant assurances that are of general applicability, and there are some that are specific to the project. So we'll start looking at some of the general applicability grant assurances. There are some that deal with issues such as access to the airport and the relationship with users. And Steve is going to talk about Grant Assurance 22 and 23 here in a little bit. There are some grant assurances that deal with finance and revenue issues dealing with the entire airport. And Leila is going to be talking about some of those obligations. There are some that deal with operations and safety for the entire airport. Some of them deal with the requirement of ownership and control of the airport. And of course, there are federal requirements that are applicable to any type of grantee-grantor relationship with the federal government. Next slide, please. And of course, then there are some project-specific requirements, such as the capability of the sponsor to carry out the project, or the requirement that there be local involvement with the local community, or obligations about the project implementation itself, or the project finance itself. And of course, also there are general federal requirements that are applicable to the project. And again, generally applicable to the project because of the relationship between grantee-grantor with the federal government. So we will be talking in this session, we will be talking mostly about the obligations of general applicability, but you need to be aware that some of them are applicable very specific to the project. Next slide, please. So the next question is, so how long do these obligations last? Typically, the ones that are project specific, the grant assurances that are project specific, last for the duration of the project. We refer to that as the grant closeout, right? Once the grant is closed out, the project means that the project has ended. In some instances, some of the financial requirements have an additional 3 years of life, and that's because of the need to do audits and such. There's also then the ones that are the obligations that are more general to the airport have a lifespan generally of the useful life of the asset that is acquired through the project. So if it's an apron or a building or a fire truck, whatever is the useful life of that asset is the life of that obligation, up to 20 years. That's the maximum. However, if the grant was obtained to acquire land, then the obligation is indefinite because land does not have useful life. It has an indefinite life. There are some obligations. There's one in particular that the obligation lasts for as long as the airport is an airport, and Steve is going to be talking about that one in Grant Assurance 23. And then there is some that is indefinite, that runs with the land. Once the obligation attaches to the land, it will then run indefinitely with the land, whether it is used as an airport or for any other purpose. And we're going to be talking about that obligation in a little bit. But let's start looking at some of these in more detail. As I mentioned, Leila will walk us through a couple of the finance and revenue assurances. So Leila, the floor is yours.
Thank you. I want to talk about these two assurances together at first, because Grant Assurances 24, fee and rental structure, and 25, airport revenues, are really sister concepts. They're intertwined and related. They really talk to airports about how we're allowed to earn, spend, and protect airport dollars. And we're obligated to run our respective airports for the good of the traveling public. And these grant assurances provide us guidance on how we can ensure that we have the financial capability to do just that, to keep those airports operating. 24 is commonly referred to as our self-sustaining obligation, and 25 is referred to as the prohibition against revenue diversion. Next slide, please. Under Grant Assurance 24, the self-sustaining obligation, the FAA tells us that airport sponsors have to maintain a fee and rental structure for the facilities and services at the airport, which will make the airport as self-sustaining as possible. And they go on to say that this is under the particular circumstances of that airport. And that makes sense, right? We have to bring in money so that we can continue to operate with our core obligation of providing services to the traveling public. These grant assurances are contractual. The promises that, as has been explained and described, these are promises we make. So it's a contract as part of our grant agreements, but they also exist independently in federal law. And I would also point you, we'll have some resources at the end, but these are areas where it's really helpful to look at the FAA revenue use policy and perhaps the rates and charges policy to flesh out some of the nuances of these two grant assurances. So I would say that if you look at what does it mean to be self-sustaining, the FAA has told us that airfield rates and charges should be cost recovery. And really specifically, they're telling us you can't make a profit off of the airfield. The goal is to be made whole. Now, actually, some airports may not even be able. Remember, the FAA did put in that language that said under the particular circumstances of that airport. Not every airport is able to charge rates and charges that will sustain the airfield costs, but to the extent you can, you want to be made whole on your airfield costs. For other aeronautical uses of your airport, your fees and charges must be reasonable. So that's super helpful. What does reasonable mean? It could mean different things to different people, but let's care about what the FAA says reasonable is. That'll depend on the circumstances of your airport and can range from a pure cost recovery model to fair market value, depending. If market conditions, you know, again, we talked about the requirement to be as self-sustaining as possible, and also fair market value obviously differs from place to place. Non-aeronautical facilities and services, however, you really need to charge fair market value. There are some exceptions, but the beauty of the non-aeronautical revenue stream is that you're actually able to use that. If you wind up having a surplus there, you're actually able to use your non-aeronautical revenue to subsidize your aeronautical business. And that's great because, again, this all goes back to what our core business is, and that's to keep things operating for the traveling public. Well, does the FAA acknowledge that we don't want to always charge fair market value for airport property? They do, right? So there are some community purposes which are eligible to charge below market rents. Nonprofit aviation organizations, an example would be a museum or Civil Air Patrol, transit projects, and military aeronautical units. As Erin said, the devil is in the details. There's many, many nuances and caveats that you can find in the policies. But those are some general concepts. And really what the FAA is saying by allowing these exemptions is saying, well, you know what? They actually have an independent benefit, right? So even if they're not directly paying you cash for the use of that for the use of your land, there is a benefit to civil aviation, and there may be a benefit to the airport itself. The community acceptance may increase, and just the outlook on civil aviation. And FAA recognizes that and says that we can charge below market if you're able and willing to do that. I do want to call out one thing that I think might be a little bit counterintuitive. At least it was for me when I learned this at a conference 15 years ago. So I am sure to always include this in conferences when I'm asked to present. But we talked about the fact that military aeronautical units you can treat in a specific way, but I want to point out that police and fire that operate aircraft at the airport are not in that same category. They do have to pay reasonable rental rates, just like any other aeronautical user at the airport. So if you can't really just allow police to have a helicopter hangar for free. The benefit of having them there doesn't count in that same way. This is not like a gas station operator who says, I want the patrol car, parked in front of the gas station. There's a benefit to me in that. We cannot consider it the same way. However, there is some common sense application here, which is if you do get a direct benefit from, for example, that police helicopter, let's say 3 times a year they take you up, you do aerial photography, or they help you look for FUD, or whatever the case may be, or there's some security function, you can offset that, but it does have to be a direct benefit to the airport. Next slide, please. So the sister concept of the prohibition against revenue diversion, the self-sustaining obligation talks about the fact that we have to charge a certain amount, right? We have to bring in a certain amount of money, revenue. And then the prohibition against revenue diversion says, once we have those funds, once we have that money, what are we able to do with it? So let's start off with defining airport revenue. It includes all fees, charges, rents, or other payments received by or accruing to the sponsor. And obviously that means the money that you've been paid or that is owed to you, right? So you can't just say, never mind, don't pay me for that, because that's really revenue accruing to the sponsor, to the airport. And all really means all. The FAA has even addressed, what if you purchase land and you sell that land and you purchase that land with airport discretionary funds? It wasn't grant funded to begin with. That doesn't matter. It's still considered airport revenue. It's a fee or payment accruing to the, or paid or accruing to the sponsor, and that is also included. There are some common sense things where it would be excluded. I think, for example, like a parking ticket fine, if someone parks in a handicap spot, I think that money has to go to a specific thing. That's for a violation of state law. That's different. But basically anything that's owed to you or paid to you, you treat within these rules. So revenue diversion is prohibited. That means when you spend the money in a way that you're not allowed to do. So let's start with the obvious question. What are you allowed to spend money on? And the basic phrase, the mantra of it is the capital and operating costs of the airport. The legislative history shows that Congress was very concerned with the idea that they didn't want cities or units of local government in those instances where they own and operate the airport. They didn't want those general funds to basically supplement their coffers with revenue from an airport enterprise fund. But airports that are not owned by units of local government can still benefit. I mean, these rules still apply to them as well, but still benefit from those guidelines, because there can be a lot of pressure on airports to give favorable deals or to help the communities in which we live with uses of land or below market rates. And the revenue rules help sort of set the guidelines with how helpful can we be and ensure that we are able to protect our airports, again, to keep operating for the benefit of the traveling public. And that's one of the reasons why this prohibition against revenue diversion lasts for as long as the airport is operating as an airport. So capital and operating costs, that's obviously building facilities, paying airport staff, but what else could be included in that? And some acceptable uses are not immediately obvious. You can, and the FAA has considered and agreed that airports can do some of those things that we want to do sort of in the vein of running a business, right? We can promote competition. We can promote new air service, public and industry knowledge of our airport. We can participate in or pay for part of community activities if that expenditure is directly and substantially related to the operation of the airport. And we can pay for those of us tied to local government. We can pay for some of those general costs of government under a cost allocation plan. So perhaps if you use some procurement services from not, as airport employees, but another department that helps you, we pay into that. And that's acceptable as long as that cost allocation plan is reasonable. Back to Erin's initial comment, the devil is in the details. So while you can spend airport revenue on promoting your airport, you can't participate in general economic development. If the community activity is not directly and substantially related, maybe you buy a team on a community golf tournament, you can do that, but the FAA has said that's not directly, if it's not directly and substantially related, if it's not, then your expenditure has to be de minimis. It needs to be a minimal amount. And generally speaking, you can't pay more and you can't charge less than you ought. So if you have these questions, they come up all the time. Look at the revenue use policy, talk to your CFO, and talk to your attorney if you're not sure. One of my biggest pieces of practical advice is just not to say, well, we've done this before, because with a lot of these revenue use questions are really fact specific. So just because you've done something similar before doesn't necessarily mean, or haven't been able to do something before, doesn't mean that it's going to be the same situation this time. So it's really good to go back and analyze the particular facts with these grant assurances and the revenue use policy in front of you. And we can really sum this up with the next slide, please, Erin. And the easiest way to remember the concept that revenue diversion is prohibited is just to consider it the Vegas rule. Money that's made at the airport stays at the airport. And think about these as really helpful to you. In a way, they you know, it may feel as if some of these things are saying no, but sometimes it's really helpful to have that ability to say no. We want to be good partners to the communities we live in, and we can absolutely do that, but there is a limit, right? And these rules help us establish those healthy boundaries and protect our revenue. Protecting the airport's finances protects the airport. So we've just talked about how we pay for the airport, and I'll turn it over to Steve, who's now going to talk about grant assurances that deal with more of how we use the airport.
Thanks, Leila. Grant Assurance 22 is where we'll start. And it's probably one of the most pervasive and often litigated grant assurances of the 39. So there's a number of subparts to Grant Assurance 22, and we'll chat about some of them in a bit. But at the most basic level, you know, Grant Assurance 22 is about making the airport available for public use on reasonable terms and without unjust discrimination to all types of aeronautical users and activities. So there's a bunch to kind of unpack in that. You know, first, Grant Assurance 22 is fundamentally about access to a public airport. The federal government, you know, has invested through the Airport Improvement Program in helping to develop those facilities. And the interest that's served through Grant Assurance 22 is ensuring that an airport sponsor doesn't limit or unreasonably condition access to those public facilities. So when you impose conditions on the use of the airport, whether that's through, you know, lease terms, rules and regulations, minimum standards, rates and charges, as Leila was just discussing, those terms have to be reasonable and not unjustly discriminatory. So obviously with terms like that, it's always going to be a very fact-sensitive inquiry. And when the FAA has administered this grant assurance, it has always tended to be fairly deferential in allowing airport sponsors to develop terms that are appropriate under the circumstances of that airport governing access. But where Grant Assurance 22 comes up very frequently is when there are two or more aeronautical users that make similar use of the airport. Under those conditions, they need to be subject generally to similar terms. Otherwise, you need to be prepared to explain what the difference between those two users is that justifies the disparate treatment. That's the essence of the unjust discrimination analysis. Now, sometimes that's just the passage of time. You know, airport policies can change over time. You're not bound to treat aeronautical users the same in perpetuity. And sometimes there's other types of differences that justify different terms with different aeronautical users, like the age of facilities or the extent of their investment in the airport. But the point is that you need to be prepared to justify those different and disparate terms. Erin, if I could have the next slide, please. So, you know, I've used the word aeronautical a lot. Leila used the word aeronautical a lot. We'll talk about it more as the presentation continues. So it's really really important to understand what that difference is. You know, the FAA considers any activity that involves, makes possible, or is required for the operation of aircraft, or that contributes to the safety of their operations to be aeronautical. Another, you know, kind of shorthand way of phrasing the distinction is, am I dealing with an operation that requires access to the airfield infrastructure? If so, it's an aeronautical activity. If it can be done without access to an airfield, then perhaps it is a non-aeronautical activity. So for purposes of Grant Assurance 22, this is really important because it only applies, the unjust discrimination requirement only applies to aeronautical activities on the airport. So things like ground transportation companies, restaurants can't complain about unjust discrimination, although there are certainly other laws that could potentially govern their activities. Next slide, please, Erin. So as I mentioned, Grant Assurance 22 imposes a number of really specific requirements. First, it's a little unique because most grant assurances apply only to the airport sponsor. But Grant Assurance 22 also requires that you insert and enforce provisions in all of your agreements that authorize, all the agreements that are authorizing entities to provide aeronautical services, that they will provide their services on a reasonable and not unjustly discriminatory basis as well. So that means if you receive complaints that an aeronautical business on your airport, an FBO, for example, is charging unreasonable or unjustly discriminatory fuel prices, or is maybe denying access to a hangar complex that it controls, then you as the sponsor have a grant assurance obligation to investigate, and if it's necessary, ultimately take appropriate action to ensure that the FBO fulfills that contractual obligation that they have to you. Grant Assurance 22 also specifically requires that FBOs are subject to the same rates, rents, and charges, again, for similar use of the airport. So lease rates can be different, based on the age of facilities, the extent of different FBOs investment, but things like fuel flowage fees and other kind of uniform charges need to be the same under Grant Assurance 22. This grant assurance is also where the right to self-service comes from. So we're not talking about like a self-service pump that might be provided at the airport, but rather a user's broader right to perform their own maintenance activities, cleaning, purchasing fuel from their preferred providers, bringing it onto the airport to fuel their own aircraft. It's a limited right because users have to can only perform these kinds of activities on aircraft that they themselves own or have exclusive control over, and even then it's either them as an individual or their own employees, not independent contractors, that can perform this self-service function. And sponsors can also establish reasonable and not unjustly discriminatory conditions on self-fueling to ensure the safety of the airport. But what Grant Assurance 22 requires is that folks have a reasonable opportunity to self-fuel and perform self-service. Grant Assurance 22 also specifically requires that when the sponsor is providing aeronautical services itself, Grant Assurance 22 applies. Now, there's situations where a sponsor elects to be the exclusive provider of an aeronautical service, and we'll talk about that momentarily. But if you are providing services like fueling in common with others, so one example that comes up frequently is the sponsor will provide a self-service pump while there are other FBOs at the airport that are performing full-service fuel. Under those situations, you can't grant yourself as the sponsor more favorable terms without running afoul of Grant Assurance 22, again, at least without appropriate justification. And then finally, safety and efficiency-based restrictions are also subject to Grant Assurance 22. It's not just about the economic terms of airport access, but unlike those economic terms, the FAA, through Grant Assurance 22, the FAA specifically indicates that it is the final arbiter of whether a restriction is necessary for safety reasons. That's not something that the FAA will defer to a sponsor on, and Grant Assurance 22 comes up a lot when users are denied access to an airport because the sponsor considers an operation unsafe. It's really something that needs to be closely coordinated with FAA. Next slide, please. So, we already touched on a few areas where Grant Assurance 22 comes up, but I also wanted to briefly hit on a couple of very specific items. First, to avoid unjust discrimination claims, a lot of airports have adopted, at the FAA's recommendation, minimum standards, which essentially set forth those minimum terms that someone that wants to do business at the airport needs to comply with. So minimum standards are a really great tool to ensure compliance with Grant Assurance 22, because if they are reasonable, they're set at a reasonable level given the circumstances of your airport, and if you enforce them uniformly, then kind of by definition, you can't have an unjust discrimination problem, right? You're holding everybody to the same requirements. But issues often arise when minimum standards are not uniformly enforced, and when you start making exceptions or waiving them for particular operators, or if there's a juggling is the term that the FAA uses, where you change minimum standards frequently. That's when minimum standards create more Grant Assurance 22 problem than they help to solve. It's also regularly an issue when someone cannot obtain access to the airport and there is space available for their operations. If it's a safety concern, as I said earlier, it's something that really needs to be coordinated and evaluated with the FAA. And in the overwhelming majority of cases, FAA will find that there are mitigation measures far less severe than a denial of access to accommodate a safety concern. So those are issues that the FAA scrutinizes very, very closely, and it's important to treat new applicants fairly. And then finally, it's important to think through the effect of Grant Assurance 22 on individual business decisions, that happen every day. You really need to be asking yourself, particularly with things like leasing policies or new businesses that are coming to the airport, am I comfortable treating similarly situated users similarly here on a going forward basis? So if you're going to grant a 50-year term to someone that's developing a $500,000 hangar facility, are you comfortable giving the next person that comes to you with a similar level of investment a similar term? Or do you need to start generating a record of what distinguishes this project that you have now from others that might arise in the future? So leasing policies can definitely evolve over time, but the point is that you can't go back and forth based on subjective views of a particular operator. And unfortunately, we see a lot of just bad business decisions that come back to haunt sponsors later in the form of an unjust discrimination claim, because there wasn't nobody was thinking through the precedential effect under Grant Assurance 22 that a particular business decision might have. Next slide, please. So from there, we'll jump over to Grant Assurance 23. And this one prohibits sponsors from granting an exclusive right to provide aeronautical services to the public. This one's also a little bit unique because it's not only a grant assurance obligation, but it also applies by statute to any airport which has ever received federal funding. And as Pablo mentioned, this is one of those grant assurances that last in perpetuity once you have accepted federal funds. Next slide, please. So one question that comes up all the time is, well, my airport, other airports, they only have one FBO. Does that mean that they've granted an exclusive right? And the answer, of course, is no. The prohibition on exclusive rights doesn't require a sponsor to make sure that there's competition at the airport. It only prevents the sponsor from entering into an agreement or managing the airport in such a way as to perpetuate the kind of single FBO environment or other lack of competition among aeronautical operators. So it's acceptable if you're a small airport, you've got an FBO that's gradually expanded, and it's likely to be the only FBO. That in and of itself is not an exclusive rights violation. The Grant Assurance 23 also doesn't apply, as I had alluded to earlier, if the sponsor elects to be an exclusive provider of aeronautical services. So, many airports operate their own FBOs. In fact, the GAO just released a long anticipated report just a few days or weeks ago, kind of summarizing this practice and exactly how pervasive it is. It's a limited exception because airports that are exercising the proprietary exclusive right really have to be doing it with the sponsor itself has to be doing it through the sponsor's employees. You can't hire an agent or an independent contractor to exercise this right for you, because then that would be granting an exclusive right. So it really applies narrowly to services that are being provided by the sponsor. And aside from that, there's a number of ways that exclusive rights issues can and do come up. You can't grant an express exclusive right, promising a user that they will be the exclusive provider of a certain service. You can't give them contractual rights that they can use to limit competition. But more common is the possibility of granting a de facto or a constructive exclusive right. And this is where you've established policies or procedures that effectively block out competition. So, for example, setting minimum standards that are so high that there is no room left at the inn for another operator to come in and compete with an existing service provider. You can also grant an exclusive right by leasing land to an aeronautical operator that's beyond what they can put to beneficial use in a reasonable amount of time. Sometimes that's granting an option agreement for additional land or a right of first refusal, because again the function there is that they can use the user's contractual rights or their option rights to block out competitors that might otherwise be qualified and be willing to provide services at the airport. So from there, I think we are going to back to Pablo.
Thank you, Steve. So let's switch gears for a little bit and talk about safety issues. Grant assurances related to safety and the operations of the airport itself, and clearly the principal one is Grant Assurance 19, that requires the airport to operate at all times in a safe and serviceable manner. It also requires the airport sponsor not to permit any activity that would interfere with the use of the airport. And then there's also a requirement in the grant assurance that requires the airport sponsor to get FAA approval before closing the airport for non-aeronautical purposes. And in fact, this and Grant Assurance 22 that Steve just talked about a few minutes ago. Remember that Grant Assurance 22 has an affirmative requirement that the airport to make the airport available as an airport to the public. And of course, implicit in making the airport available to the public is that the airport be open. So the requirement that under Grant Assurance 22 that the airport remain open, and the requirement under Grant Assurance 19 that the sponsor must seek FAA approval before closing the airport is the reason why airports were required to remain open during the COVID pandemic. Other common requirements related to this grant assurance is the operation of lights on the airfield, right? The requirement to mark hazards at the airport, the requirement to publish notice to airmen for any conditions that may affect the use of the airport. All of those. The last one I want to mention is the requirement to develop and implement wildlife management plans. Now, there's another requirement for Part 139 certificated airports, that is the airports that have regular passenger service. they have a requirement to have a wildlife management plan, to have it and to implement a wildlife management plan. But there are instances under which a general aviation airport is required to have such a wildlife management plan, and that flows from this grant assurance obligation. Next slide, please. So let's talk a little bit about the implementation of this. When is the airport operating at all times in a safe and serviceable manner? Well, FAA looks, and by the way, this is a standard that truly applies to all grant assurances, but I'm going to discuss it in its applicability to this one specifically, but the principle applies to all grant assurances. FAA wants to ensure that the sponsor of the airport fully understands its obligations, that it makes the resources necessary to implement that obligation, to meet that obligation available, and that it adopts and implements a detailed program to carry out the commitment. Now, these are, again, this comes from the, and I have the citation there from the Airport Compliance Manual, but it's really the same principle that FAA applies to all other grant assurances on whether or not the airport is in compliance with them. So let me give you an example of an instance in which the airport was found to be not in compliance with Grant Assurance 19. And this comes from the case of Valley Aviation Services against the city of Glendale in Arizona. In that case, the FAA found the airport sponsor to be in violation of Grant Assurance 19 because it allowed the operation of non-aeronautical businesses and the storage of non-aeronautical items in an aeronautical area of the airport in a way that interfere with aeronautical activities. So as a result of that, the FAA found that to be in non-compliance with Grant Assurance 19. And incidentally, it is that case that led, some of you may be familiar with it, it's commonly referred to as the hangar use policy. It was that case that triggered the FAA to develop and implement the hangar use policy. Next slide, please, Erin. So switching gears once again, let's talk about Grant Assurance 5, which is preserving rights and powers. Now, this is what I refer to as a catch-all grant assurance, right? In other words, in order to enter into a grant agreement, the airport sponsor must certify that it has the rights and powers necessary to comply with all of the obligations of the grant agreement, including all of the grant assurances. This grant assurance says that the airport sponsor must preserve the rights and powers that it already has that are necessary to comply with all of the other grant assurances. So it's a legal requirement, right? There is another part of the Grant Assurance 5 that also talks about it's a prohibition of encumbering or disposing of obligated property. And here we go to that reference that Erin made at the very beginning of the presentation about Exhibit A. Whatever happens to be in Exhibit A is obligated property. So there's a prohibition about encumbering or disposing of any obligated property without FAA approval. That has been modified by the FAA Reauthorization Act of 2018 a little bit, and Steve is going to talk about that here in a few minutes. There is another part of Grant Assurance 5 that deals with noise projects. If the sponsor receives a grant for a noise project, the implementation of which is going to be carried out by another local government entity, then there is a requirement of an agreement between the sponsor and that other local government. But that is very specific and only applies in very narrow set of circumstances. Next slide, please. So let me give you some examples in which airport sponsors run afoul of this obligation. There's a case, Boston Air Charter against Norwood Airport Commission, in which the FAA found that the airport sponsor had signed an 80-year lease, which in itself is a problem. FAA considers any lease that exceeds 50 years to be the disposal of airport land. It had signed an 80-year lease, and in doing so, it had failed to preserve the sponsor's rights to enter the leasehold or to grant utility easements through the property. In doing so, the airport had in essence, giving an exclusive right to the lessee of that property, because the airport sponsor was unable to let property around it. It was unable to run utility services to the other properties adjacent in the airport. So this is a catch-all obligation, right? So whenever an airport sponsor violates Grant Assurance 5, it is also violating some other grant assurance. And in this case, FAA had found that the sponsor had violated Grant Assurance 23 by granting, in essence, an exclusive right. And in doing so, it had violated Grant Assurance 5 because it had failed to preserve rights and powers necessary to comply with Grant Assurance 23. Another example comes from the case of Goodrich pilot training against the village of Endicott in New York. In that case, the airport had entered into an agreement with one tenant that gave that tenant a unilateral right to raise rates charged to other tenants. If you recall from Steve's presentation on Grant Assurance 22, there is an affirmative obligation on the part of the airport sponsor to insert and enforce provisions in agreements with aeronautical service providers requiring that the services be provided on a reasonable basis. By granting the unilateral right to one tenant to raise rates on other tenants, the airport, FAA found, violated not only Grant Assurance 22, but also Grant Assurance 5. And the last example I want to give you is from the case of Moore against Sumner County Regional Airport Authority. And this was just a case in which the FAA found a violation of Grant Assurance 5 because the airport was being run in such a slipshod manner. The FAA found that there were ad hoc procedures. It was not really transparent decision making, and in essence, the way the airport was being run, it had eroded the sponsor's ability to establish the programs necessary to ensure compliance with the grant assurances. So it gives you a sense for what it means to preserve rights and powers. Now, related to Grant Assurance 5's obligations not to dispose of airport land without FAA approval is Grant Assurance 29, and Steve is going to talk about that.
Thanks, Pablo. So Grant Assurance 29 requires that the sponsor maintain an airport layout plan, which is often just referred to as an ALP. So the ALP is actually not just one drawing, but a series of drawings. And the FAA explains, what those drawings need to be, the kind of information that they need to contain in an advisory circular, which by the way, if we haven't mentioned it, but almost all of the grant assurances, are kind of further expanded upon through advisory circulars. And if you read the beginning of an advisory circular, it'll often say, compliance with this advisory circular is mandatory for grant obligated projects or grant obligated airports. So it's a really important source of information to understand what your grant assurance obligations actually are. But at a basic level, the ALP is going to show all of the boundaries of the airport, the land boundaries, as well as proposed additions to the boundaries of the airport. It's going to show off-airport areas that are under the airport sponsor's control, or property interests that you have off-airport, like navigation easements. And the ALP is also going to show all of the airport's existing and proposed facilities. So, structures, hangars, terminal buildings, aircraft parking areas. This obligation applies both on the air side and land side. It's all of the facilities and structures available at the airport. And then it's also going to show areas that have been approved by the FAA for non-aeronautical use. So the ALP is important for a couple of reasons. First, it's the primary means by which the FAA evaluates sponsors' compliance with a number of other grant assurances. So you can look at the ALP and you can determine, whether an airport has good title to airport property or sufficient property interests to comply with, Grant Assurance 5, as Pablo discussed. You can also determine whether or not you've got non-aeronautical uses occurring on the airport on property that's been designated for aeronautical use, and it helps the FAA assess whether rates and charges are being set appropriately or whether there's a diversion of airport revenue. It's also important because sponsors are not allowed to undertake or allow any development on the airport unless it's depicted on the ALP. Through the ALP, the FAA has the opportunity to review and change and approve changes to airfield geometry to make sure that it complies with standards, as well as other kinds of airport development. And if you go ahead and develop facilities that are not first depicted on your ALP, and the FAA determines that they might impact the safety, utility, or efficiency of the airport, then Grant Assurance 29 will require you to either mitigate those effects or potentially demolish the facilities that weren't depicted on the ALP if that's the only means of resolving the safety concern. So Grant Assurance 29 was very recently, as Pablo mentioned, was modified by the FAA Reauthorization Act of 2018, Section 163, which essentially narrowed the FAA's authority to regulate the use of airport property generally. So under Grant Assurance 29, you still need to maintain an up-to-date ALP, just as you always have. But it used to be that any material change to the ALP required FAA approval. And the FAA's approval would in turn trigger other obligations like FAA's obligations under the National Environmental Policy Act, or NEPA, which, that could, it could stall development projects in some cases. It'd be fatal to development projects because the FAA's approval triggered a lengthy, time-consuming and at times expensive process. But under Section 163, when you now submit a change to the ALP, the FAA first undertakes a screening process to determine whether or not the proposed change falls within one of three zones of interest. And those are generally, does the change have an impact on the safe and efficient operation of aircraft? Will it impact the safety of people or property on the ground as a result of aircraft operations? Or will it affect the value of prior federal investments to a significant extent? And if the change doesn't fall within any of those zones of interest, then the FAA will tell you that, and they will accept the change to the ALP without needing to approve it, which then allows you to move forward much more expeditiously with the project. Again, we could have an entire session on Section 163 and how it's kind of changed the landscape. So if you've got, a development project and you're, have questions over whether or not Section 163 applies, best to consult with counsel and ultimately consult with the ADO before moving forward. And I will kick it back over to Pablo for discussion of, I think, one last grant assurance that's a little bit different.
That's right, Steve. Thank you. I was going to say now for something totally different is Grant Assurance 30, dealing with civil rights. This is a grant assurance that implements the Civil Rights Act of 1964 as applicable to recipients of federal grants. It really predates many, except probably with the exception of Grant Assurance 23, it predates all of the other grant assurances. And so it predates the Airport Improvement Program itself, the ADAP, FAP programs. It goes back to the mid-1960s. In essence, this prohibits the sponsor from discriminating in providing access to the airport or participation in airport programs. And it has a very strong affirmative obligation on the part of the airport sponsor. It requires the sponsor to, quote, I'm going to quote it here, promptly take any measures necessary to ensure that no person is discriminated against. So it's a very broad obligation. And next slide, please. And the applicability of this obligation is really, really broad. Once the airport accepts a grant with this obligation attached to it, the obligation applies to all of the sponsor's programs or activities. If the grant is to fund a particular facility, the obligation that applies to all of the other related facilities. If the grant is for the acquisition of land, it applies to space on, over, or under the property. It applies for as long as the airport is an airport, but there is a requirement, and I will touch on that requirement here in a second, to include this obligation in land transfer documents. So in essence, the effect is that this obligation lives in perpetuity. Once the airport has accepted money from the federal government, Grant Assurance 30, the obligation to not discriminate, attaches to that land, and then it runs with the land forever. So what are the requirements, the mechanical requirements, what the sponsor has to do? And these are again, I refer to them as the mechanical requirements. The sponsor has to include a non-discrimination notice in all bid requests, RFPs, etc. It must include, non-discrimination language in all contracts subject to 49 CFR Part 21, but you can go take a look at 49 CFR Part 21. You will have to read Appendix A, and you will see the list of contracts. In essence, for all practical purposes, every single contract that the airport sponsor enters into should have a non-discrimination language. And here's the part about making this obligation live in perpetuity for that piece of land. It requires non-discrimination protection language to be added to property transfer documents so that this non-discrimination protection will run with the land. And one last point to make on this particular grant assurance is that it very explicitly says that the United States government may seek judicial enforcement on this grant assurance. So speaking of enforcement, Steve.
Thanks again, Pablo. So, we've walked through kind of 8 of the key grant assurances out of the 39. But at this point, we wanted to switch gears and talk a little bit about the way that the FAA enforces these grant assurance obligations. So there's essentially 2 different modes of enforcement, if you will. The first is Part 13, which is sometimes referred to as an informal process, and the other is Part 16, which is referred to as the formal process. And they get their names, Part 13 and Part 16, because this is where the procedures are codified in the Code of Federal Regulations, Title 14 CFR, Part 13 and Part 16. So under a Part 13 process, it is quite informal. It can be a report of potential non-compliance can be brought by any person, really in any kind of format, and it runs the gamut as far as levels of formality. And we've seen everything from a brief email, a couple of sentences long, all the way to a full-blown brief submitted to the FAA. But what will generally happen is that the FAA will conduct an informal investigation that's run out of either the airport's district office or occasionally at the regional level. It'll generally forward whatever form the complaint is and ask for the airport sponsor to respond. Sometimes there'll be some additional back and forth. But at the end of the process, which is generally 30 to 90 days, I would say on average, the FAA will issue a compliance determination. But it's not what's considered a final agency action. And it will say as much on the face of the order itself. Given the informality of the process, it's essentially an advisory opinion as to how the FAA views the sponsor's compliance, given the facts that were before it, and whatever investigation it conducted through the Part 13. If the complainant is not satisfied with the FAA's decision, or if the FAA determined that there was potentially non-compliance and the sponsor fails to act on that, then the complainant needs to file a Part 16 complaint, or in some cases the FAA will file a Part 16 complaint. But that's not to say that there are no consequences to a Part 13 at all, because if the FAA finds the sponsor is not in compliance, then what it will do is typically ask for a corrective action plan. And if the corrective action plan is not submitted or it's not satisfactory to the FAA, then often FAA will withhold discretionary AIP grants until a corrective action plan is submitted and compliance is restored. And being on the wrong end of a Part 13 complaint can also subject an airport sponsor to enhanced oversight, because the FAA is aware of a non-compliant condition, and in many cases it will go out of its way to look for more. A Part 16 complaint or a Part 16 process is much more formal as compared to a Part 13. It can be commenced in essentially one of two ways. Brought by the FAA itself. The FAA can file what's called a notice of investigation to kick off the process. And it can also be brought by a person that is directly and substantially affected by the non-compliance. So there's a little bit stronger of a requirement to commence a Part 16. And in order to do that, the complainant also needs to certify that they tried to take informal efforts to resolve the issue before commencing the Part 16 process. So the Part 16 is full-blown administrative litigation. Parties need to file briefs. They need to submit, formal evidence to support all of their claims. If you're the complainant, all of the defenses. If you're the airport sponsor, these are generally very, very robust filings because the rules require that you submit kind of all of the evidence up front. Those of you that are lawyers or familiar with the legal process know that in a lot of litigation, there's what's called discovery, where people kind of exchange the evidence. That's not the case in a Part 16. You kind of need to give the FAA everything that you've got right at the beginning. At the end of the briefing process, there is an initial decision that is issued by the Director of Airport Compliance, which is called the Director's Determination. And if there's a finding of non-compliance, and depending on how the penalties that the FAA is choosing to elect, there may, after the director's determination, be an opportunity for a hearing, which is essentially, like a trial, and it looks very much like a trial that you might see on TV, but it's about grant assurance compliance. And then from the hearing, or from a director's determination, if there is no hearing, you can appeal to the Associate Administrator for Airports at the FAA, who will issue a final agency decision that can then be appealed to a federal court. So this is a very time-consuming, often very expensive process. And you really want to have experienced counsel kind of shepherding the sponsor through that process because of the potential consequences, which we'll talk about in a minute. But before talking about the kind of specific enforcement tools available to the FAA, it's important to note that grant assurances are not generally enforceable by private parties outside of this process. So sometimes, an airport user, an FBO, an airline, other aeronautical users will try to sue an airport sponsor directly for violating the grant assurances. And courts have generally said, no, you can't do that. When the FAA, developed these enforcement procedures, and Congress vested the FAA with the authority to develop these procedures, it was intended that these would be the only means of enforcing them. And that's important because it means that, aeronautical users are not entitled to money damages for violation of the grant assurances. Their venue for being heard and the remedies that are available are limited to those remedies that the FAA has. But it's also easy to undo that protection if you incorporate the terms of grant assurances, either in whole or in part, into your agreements with aeronautical users. So, if you are making a contractual promise to an aeronautical user in a lease, that you're not going to unjustly discriminate, with respect to their operations, and then you do, then there is a possibility that an action, a breach of contract action, can be brought against you directly in federal court. An important consideration for drafting agreements. Erin, if we go to the next slide. And then, so I mentioned there's a number of enforcement tools or penalties that are available to the FAA in the event of non-compliance. The first one, the ability to withhold discretionary AIP funds, as I said, is something that's always available to the FAA, even at the conclusion of a Part 13. It's, they're discretionary funds, so the FAA can exercise its discretion however it would like. The others, however, need to be issued in the context of that Part 16 proceeding. So the FAA can withhold approval for AIP apportionment funds if there is a formal finding of non-compliance. It can also suspend payments under existing AIP grants and just refuse to make those reimbursements if there's a finding of non-compliance. The FAA can issue whatever administrative orders it finds necessary, including cease and desist orders. So for example, if you are proposing to demolish an airport runway and the FAA believes that that would violate your grant assurances, it can issue an administrative order, telling you that you may not do that. That can then be enforced in federal court, and and continuing to violate the grant assurances at that point would be an act of contempt. There are also a number of specific remedies that are available to the FAA with respect to revenue diversion. And Leila kind of explained why that is such a big deal to the FAA. And so there are a number of specific remedies available. The FAA, in addition to all of the things that we've already discussed, can revoke authority to collect passenger facility charges at the airport after a finding of revenue diversion. It also has authority to direct the termination of non-AIP federal grants. So if you're receiving grants, for example, from the Federal Highway Administration or the Federal Transit Administration, the FAA can suspend those grants for revenue diversion. And the FAA can also assess civil penalties for a revenue diversion up to 3 times the amount of diverted revenue. So those kind of 3 unique remedies just go to show how seriously the FAA takes revenue diversion problem. And then there's a couple of kind of unique remedies that arise, fortunately much more rarely, but that do arise, that Pablo will discuss.
Thank you, Steve. Yes, while private parties cannot enforce grant assurances, the FAA generally does. But there's another possibility that DOJ can enforce the violation of grant assurances through the False Claims Act. It doesn't happen very often, but it has happened. Under the False Claims Act, liability attaches to a person or to an entity when that person knowingly presents false or fraudulent claim, or when that person knowingly makes a false record or statement, or that person conspires to a violation. So that is something to keep in mind. It is a very, very important step when someone on behalf of the airport sponsor signs the grant agreement and is signing and certifying not only to the grant agreement, but to the grant assurances in general. And we know of at least one example in which FAA found after informal investigation, found a violation, accepted a corrective action plan from the airport to correct that violation, yet DOJ continued to prosecute the case. Eventually, the case was settled and it was resolved with DOJ as well. But you need to keep that in mind. That it's not only the FAA that can enforce these obligations, but under the False Claims Act, the Department of Justice may as well. And with that, Steve, unless you have anything else, I think we can pass it on to Erin.
So I'm going to sort of wrap everything up for us here. One of the things that we thought was important is to provide you with some resources that you could use to access some of the documents and information that we have been referencing. In particular, I just draw your attention to that first bullet, which contains the link to the FAA Airport Compliance website. It's a robust website that has lots of links to other documents. And those links include links to documents that we've discussed here today, including the revenue use policy, the airport compliance manual, both of which we've mentioned today, and both of which I use all the time in my work here at RDU. And so there's a brief list of some resources that we think that you will find helpful. And then additionally, we thought that you might find our contact information helpful, and I've asked all the panelists, and they have generously agreed that if you have questions or want some more information about resources or a point in the right direction, we're all open to you contacting us. This is our email addresses, and we'd be happy to have you follow up with us. That sort of wraps up our panel today, and I would like to thank the panelists for participating and preparing for this session today. I thought it was a great panel, a great session, and I really appreciate them lending their expertise and knowledge to this panel. My team at RDU often tells me that I'm not allowed to attend any conferences because I always come away with lots of notes and lots of questions, and I come back asking them, hey, are we doing this? Hey, are we doing this? Are we doing this? Part of me says that I hope that we spark that in you in watching this sort of bonus session panel that we put together. But in any event, I hope that we raised some thoughtful questions for you and that you enjoyed this panel. We appreciate you watching this bonus session. Thanks so much.